Hello, good evening. This is welcome to Telugadda Friday RoundUp. Today we are having a special episode with two distinguished guests. Both are legal luminaries. One is Mr. Jurist Justice Nagmohan Das, and the other one is. Hello, good evening. This is welcome to Telugadda Friday RoundUp. Today we are having a special episode. The other guest of the day is Mr. Professor Ramakrishna, Assistant Professor Ramakrishna Prasad Garu. Welcome, sir. Unfortunately, today because of heavy pouring of rains, Justice Nagmohan Das Garu could not join the show because he got very unstable internet connection. So he issued to address the Telugadda audience on some other occasion the same week, this week, forthcoming week only. So today we are going with Ramakrishna Prasad Garu. Sorry for the inconvenience, sir. As we are addressing both the Telugu and non-Telugu audience, let me have a formal welcome to our Telugu regular audience who are following Telugadda on every Friday at the same time. మిత్రులారా మా తెలుగడ్డ ఫ్రైడే రౌండప్కు స్వాగతం. ఈరోజు స్పెషల్ ఎపిసోడ్ కింద తీస్తా సత్లవాడ్ పైన ఇచ్చినటువంటి సుప్రీంకోర్టు తీర్పు నేపథ్యంలో భారతదేశంలో న్యాయపాలన పర్యవసానాలు అనే లోతైన అంశం పైన చర్చకి మనం ఇద్దరు ప్రముఖ నిపుణుల్ని ఆహ్వానించాం. జస్టిస్ నాగమోహన్ దాస్ గారు బెంగళూరు నుంచి పాల్గొనాల్సి ఉంది. అనివార్య కారణాల వల్ల అక్కడ బెంగళూరులో బాగా విపరీతమైనటువంటి వర్షాలతోటి ఇంటర్నెట్ అన్స్టేబుల్గా ఉంటుందో ఆయన జాయిన్ కాలేకపోతున్నారు. మరొక సందర్భంలో ఈ వారంలోనే ఇదే అంశం మీద మరొకసారి మాట్లాడతాను అని చెప్పారు. మనతో తన అభిప్రాయాలు పంచుకోవడానికి ప్రొఫెసర్ రామకృష్ణ ప్రసాద్ గారు ఉన్నారు. రామకృష్ణ గారు నమస్కారం. ఇది రెండోసారి మిమ్మల్ని మేము ఆహ్వానించాం. ఇంకా దాదాపు ఒక సంవత్సరం క్రితం అనుకుంటాను భారతదేశంలో ఉగ్ర చట్టాలు అనే అంశం పైన మీరు నాగమోహన్ దాస్ గారు అగైన్ సేమ్ ప్యానల్ మాట్లాడారు. టుడే వీఆర్ హ్యావింగ్ అనదర్ ఎపిసోడ్ విత్ యూ. మిత్రులారా, జకియా జాఫ్రీ యాక్చువల్గా సుప్రీంకోర్టు ఇచ్చినటువంటి తీర్పు జకియా జాఫ్రీ వర్సెస్ స్టేట్ ఆఫ్ గుజరాత్. కానీ ఆ తీర్పు అనంతరం జరిగినటువంటి పరిణామాలు, ప్రధానంగా శ్రీకుమార్, అట్లాగే అడిషనల్ అడ్వకేట్ జనరల్ ఆఫ్ పోలీస్గా రిటైర్ అయినటువంటి ఆర్బి శ్రీకుమార్ గారు, అట్లాగే ఇప్పటికే జైల్లో ఉన్నటువంటి మాజీ ఐపీఎస్ ఆఫీసర్ సంజయ్ భట్ గారు, ప్రముఖ సామాజిక కార్యకర్త, మానవ హక్కుల కార్యకర్త, సిటిజన్ ఫర్ జస్టిస్ అండ్ పీస్ సంస్థ వ్యవస్థాపకురాలు, నిర్వాహకురాలు తీస్తా సత్లవాడ్, మొత్తం గుజరాత్ నరమేధానికి సంబంధించి జరిగినటువంటి లోపాలని అటు ప్రభుత్వ పరంగా కానీ, న్యాయవ్యవస్థ పరంగా కానీ, కార్యనిర్వాహక వర్గం పరంగా కానీ, అటు పార్లమెంట్ పరంగా కానీ జరిగినటువంటి అనేక లోపాలని ఎత్తి చూపడంలో ఒక రకంగా బహుశా ఈ గుజరాత్ నరమేధం అనంతరం వివిధ న్యాయస్థానాల్లో నరమేధానికి కారకులైనటువంటి వాళ్ళని శిక్షించాలి అనే పిటిషన్స్ పైన జరుగుతున్నటువంటి వాదోపవాదాల్లో భాగంగానే ప్రత్యేకంగా భారత న్యాయ కమిషన్ కూడా ప్రొటెక్షన్ ఆఫ్ విట్నెసెస్ సంబంధించి ఒక ప్రత్యేకమైన రిపోర్టు కూడా రిలీజ్ చేసింది. పెద్ద ఒక 20 సంవత్సరాల పాటు సాగినటువంటి పోరాటం. ఈ పోరాటంలో ప్రధానమైనటువంటి ఆరోపణ అంటే పీడితులు బాధితుల తరపున ఉన్నటువంటి ఆందోళన, ఈ మొత్తం నరమేధానికి గుజరాత్ రాష్ట్ర ప్రభుత్వంలో అత్యున్నత స్థానంలో, నాయకత్వ స్థానంలో ఉన్నటువంటి వాళ్ళ వ్యక్తుల యొక్క ప్రత్యక్ష పాత్ర, పరోక్ష పాత్ర తోడైంది ఈ దావానాలో వ్యాపించడానికి అనేది అక్కడ ఉన్నటువంటి ఆరోపణ. దాని మీద ఒక 63 పేజీల ఫస్ట్ అప్లికేషన్ని జకియా జాఫ్రీ అహ్మదాబాద్ మ్యాజిస్ట్రేట్ కోర్టులో దాఖలు చేస్తారు. మ్యాజిస్ట్రేట్ కోర్టు దాదాపు 1300 పేజీల రిపోర్ట్లో, జడ్జిమెంట్లో పిటిషన్లో ఉన్నటువంటి అభియోగాల్ని తిరస్కరిస్తూ దాంట్లో ఉన్నటువంటి 63 మంది నిందితులకి లేదంటే ఆరోపితులకి ఏమంటాం క్లీన్ చిట్ ఇస్తూ తీర్పిస్తారు. దాన్ని మరలా జకియా జాఫ్రీ నిరసన పిటిషన్ కూడా వేస్తుంది. నిరసన పిటిషన్ కూడా మ్యాజిస్ట్రేట్ కోర్టు తిరస్కరించిన తర్వాత హైకోర్టులో అప్పీల్కి వెళ్తారు. హైకోర్టు కూడా తిరస్కరిస్తుంది. అంతిమంగా 2013-14 అనుకుంటాను ఆ టైంలో సుప్రీంకోర్టులో పిటిషన్ దాఖలవుతుంది. 2018 సెప్టెంబర్ ప్రాంతంలో మొదలై విచారణ 2022 జూన్ 24వ తారీఖుకి తీర్పు వెలువడుతుంది. ఈ మొత్తం క్రమంలో సుప్రీంకోర్టు అనేక అంశాలు, దాదాపు 400 పేజీలో ఇచ్చినటువంటి తీర్పులో అనేక అంశాలని ప్రస్తావించారు. దాంట్లో వాస్తవాలకు సంబంధించి ఇప్పటికే జస్టిస్ మదన్ లోకూర్ లాంటి సుప్రీంకోర్టు న్యాయమూర్తులు, అట్లా ప్రశాంత్ భూషణ్ లాంటి పేరెన్నికన్నటువంటి రాజ్యాంగ నిపుణులు తమ అభిప్రాయాలను వ్యక్తం చేశారు. 300 మంది పైగా సుప్రీంకోర్టులో పనిచేసినటువంటి, సుప్రీంకోర్టులో ప్రాక్టీస్ చేసినటువంటి న్యాయవాదులు సుప్రీంకోర్టు తీర్పు ఇచ్చినటువంటి తీరుని, అందులో చేసినటువంటి వ్యాఖ్యలు, దాని పర్యవసానంగా జరుగుతున్నటువంటి పరిణామాలు, వీటన్నిటినీ పునఃపరిశీలించాలి, ఆ తీర్పుని పునఃపరిశీలించాలి అని చెప్పారు. అట్లాగే ఈ తీర్పులో ఉన్న కీలకమైనటువంటి భాగం స్పెషల్ ఇన్వెస్టిగేషన్ టీం, సుప్రీంకోర్టు ద్వారా నియమించబడినటువంటి స్పెషల్ ఇన్వెస్టిగేషన్ టీం. ఆ స్పెషల్ ఇన్వెస్టిగేషన్ టీంతో పాటు అమికస్ క్యూరీగా పనిచేసినటువంటి రోహతగి, ఆయన ఈ వారంలోనే మరో టీవీలో మాట్లాడుతూ, దీన్ని అంత పెద్ద హడావుడి చేయాల్సినటువంటి అంశం కాదు, సుప్రీంకోర్టు అనేక సందర్భాల్లో అనేక తీర్పులు ఇచ్చింది, ఆ తీర్పుల్లో ఏ పారాగ్రాఫ్లు అభ్యంతరకరమైనటువంటివని మీరు భావిస్తున్నారో, అంటే కక్షిదారులు పిటిషనర్స్ భావిస్తున్నారో ఆ పారాగ్రాఫుల్ని తొలగించాలి అని చెప్పి మీరు రివ్యూ పిటిషన్ వేసుకోవచ్చు, దాంతో వ్యవహారం సమసిపోతుంది అని వాళ్ళు మొత్తం గుజరాత్ నరమేధానికి సంబంధించినటువంటి నేపథ్యాన్ని తుడిచిపెట్టే అవకాశాల గురించి ఆయన మాట్లాడారు. ఈ నేపథ్యంలో మనం రామకృష్ణ ప్రసాద్ గారిని ఆహ్వానించాం. రామకృష్ణ ప్రసాద్ గారు, సార్, మొత్తంగా సుప్రీంకోర్టు గత 2 వారాల్లోనూ సెన్సేషనల్ జడ్జిమెంట్సే ఇచ్చింది. ఒక రకంగా మహారాష్ట్ర బలపరీక్ష దగ్గర నుంచి బలపరీక్షకి సంబంధించినటువంటి షోకాజ్ నోటీసులకి రిప్లై ఇవ్వడానికి 14వ తారీఖు వరకు టైం ఉంది అని చెప్తూనే గవర్నర్ బలపరీక్షకి ముందు రోజు ఒక 24 గంటల్లోనే బలపరీక్ష చేయాలి అని చెప్పనంటే ఏది ముందు ఏది వెనుక అన్న విషయంలో సుప్రీంకోర్టు ఐ థింక్ ఇన్ఫాలిబుల్ అని అంటారు కదా, ఆ రకమైనటువంటి తీర్పుకి అవకాశం ఇచ్చింది. అక్కడి నుంచి మొదలు పెట్టుకొని నూపూర్ శర్మ తీర్పు వరకు అనేక సెన్సేషనల్ స్టేట్మెంట్స్ సుప్రీంకోర్టు వైపు నుంచి వస్తున్నాయి. జనరల్గా తీర్పు రాసేటప్పుడు అబ్జర్వేషన్స్ ఆన్ ద బెంచ్, ఆన్ ద ఫ్లోర్ ఆఫ్ దర్ అబ్జర్వేషన్స్ అని చెప్పని అంటాం. ఎందుకంటే సుప్రీంకోర్టు, అట్లాగే పార్లమెంటు, అసెంబ్లీ, ఈ 3 కేంద్రాల్లో జరుగుతున్నటువంటి నిర్ణయాలు కానీ, శాసనాలు కానీ, వ్యాఖ్యానాలు కానీ మొత్తం దేశంలో ఉన్నటువంటి 130 కోట్ల మంది ప్రజానీకం యొక్క దైనందిన జీవితాన్ని ప్రభావితం చేస్తాయి. ఈ నేపథ్యంలో మనం ఈ సుప్రీంకోర్టు తీర్పుని ఎట్లా అర్థం చేసుకోవాలి?
Okay, so good evening to one and all. Greetings from Goa. Actually, I'm supposed to speak in English. That's what we expected, and it was circulated to outside. Therefore, please excuse me for not speaking in Telugu. I hope that's okay with Viray garu.
Yes, sir.
So what am I going to speak today is that I'm not going to say whether who is behind those killings during the communal violence in Gujarat. That's not the idea of today's discussion. The title is who will watch the watchdog. So what is this watchdog is all about? So the Constitution of India provides several fundamental rights to the citizens, and it creates a mechanism if those fundamental rights are violated. That mechanism is the constitutional courts, both the High Court as well as the Supreme Court. The Supreme Court has given the power under Article 32 where it jurisdiction in case our fundamental rights are violated. So therefore, Supreme Court is widely described as a watchdog of the fundamental rights and the constitutional rights of the citizens. So therefore, we are saying if the Supreme Court is a watchdog, who will watch the watchdog? If the Supreme Court itself does something wrong, or we feel that the Supreme Court is wrong, then who would control the Supreme Court? So the observations, particularly by the Supreme Court, both in Zakia Hassan Jafri case and Nupur Sharma's case, is a matter of concern not only for the people like the law teachers and lawyers and the judges, etc., but it is for the entire society. As Viray garu has rightly identified, that the judgments of the Supreme Court is going to influence our lives. So therefore, first we need to understand the role of judiciary, and then I will discuss briefly about what is this case about. And then we will look into what are the observations made by the court and how that observations of the court is going to have repercussions on the future matters. To start with the first part of discussion today, we need to understand the role of the judiciary. Uh, the Indian Supreme Court is termed as the most powerful court in the world, though it could be arguable, but that is what the most of the people write, that the Indian Supreme Court is the most powerful court in the world. And a democratic country like India, a judiciary is supposed to be independent and must be insulated from external pressures. Therefore, if we think that the judiciary is an independent and the judges are expected to be neutral and unbiased, this is the constitutional mandate. Okay, it's not what I am saying, but it is a constitutional mandate if you are a democratic. What is the difference between the judiciary and the legislature and the executive? Is that unlike the legislature and executive, the judges are not accountable to the electorate. If you closely watched from the few days back, our Chief Justice also echoed the same thing, saying that they are not answerable to anyone but to the Constitution. So therefore, the judges in India are not elected. Hence, they have no accountability towards the electorate. And they are not answerable to anyone for their judicial decisions. Because this is a privilege that is conferred by the Constitution to the judges. That means it's kind of a privilege enjoyed by the judiciary only, but not to the legislature and executive. So therefore, why such kind of privilege or why such kind of insulation was given to the judges is that the judges would be remaining free and fearless while they are delivering the judgments. I just to draw all of your attention to Article 32, which we all know that is a fundamental right for us, and the Supreme Court has a power of issuing writs. But there is another article, Article 142. Article 142 of the Indian Constitution says, the Supreme Court, while exercising its jurisdiction, can pass any decree or make such orders necessary for doing complete justice in any cause. That means the power of the Supreme Court is absolutely unlimited while granting the remedy if for the purpose of providing complete justice. So therefore, with such an enormous power and not being accountable for their judicial decisions, the question comes, how do we make the court answerable or within the parameters of the constitutional scheme? How do we make the judges accountable when there is no accountability is insisted by them? It doesn't mean the judges can do whatever they want or the judges are not accountable at all. They have a self-accountability, that is what I call. There are, at least I identified, there are 3 ways in which the judiciary in India is accountable to its decisions. The first one is that following the principles of natural justice. That is, there are 2 principles that the judge cannot decide his own case. Second one is you must hear the other side. While you are giving a judgment, you must allow the other party to make their presentations based after hearing, then only you can decide the case. And the third principle is while you are deciding the case, you must give a reasoned decision. That means what are the reasons based on which you are giving this decision. So therefore, by looking at these, that the judgments must be clear and the judge must clearly articulate the legal reasons and show how did the judge reach to such conclusion. Okay. So therefore, it is whenever a judge giving a judgment requires a careful deliberation rather than instinctive reaction by the judge. That means the judge, while giving the judgment or making the observation, you cannot be instinctive reactions, but it should be a careful deliberation of the facts and the law and give the judgment. However, there were several criticisms on how the judges decide. Let me quote at least two legal luminaries. One is Tarnab Khaitan. He, in his one of his article, he writes that the approach of the judges, particularly when it is a small benches like 2 or 3 judges bench, the legal reasoning and interpretation is astonishingly undisciplined. And he also quotes several cases where it says that relevant, even binding the precedent is simply ignored. Just for the benefit of the viewers, precedent means suppose a higher bench of a judge, bench of 5 judges decides a case, any other bench, which is three judges or 2 judges, cannot give a decision against 5 judges bench decision. That is called precedent. Uh, then there is another person, Bhuvania, in courting the people, public interest litigation, post-emergency India. He observes that Supreme Court in number of cases, he says frequently, the actual prayers of the litigants are ignored. That means what the litigant asked the court is ignored. And court gave orders where the party is not prayed for, not asked for. And very damagingly, it says sometimes it gives judgments against the persons who were not even heard by the court in the case. And the another strong criticism on the Supreme Court, that is that the judges act as a panchayat of wise men rather than the judges of the court. So therefore, it looks like that the courts, particularly the judges, while deciding the cases, I'm not saying all the judges and all the time, but there are instances where the decisions were not purely based on law, but sometimes it is the observations made by the judges are impulsive. That is what I say. So let us come to this case of Zakia Zafri versus State of Gujarat, where recently the Supreme Court has given judgment. Just to give you an idea, the case was filed about 2-3 years back to the Supreme Court based on the judgment given by the High Court of Gujarat at Ahmedabad. So a special leave petition filed before the Supreme Court was, there was a delay of 216 days. That means after the judgment of the High Court, instead of filing a special leave petition within the reasonable time, there was a delay of 216 days. So when this special leave petition came up for hearing, the state has not wholeheartedly objected for hearing the case, particularly on the grounds of delay. Here there were 2 issues. There were 2 petitioners. First petitioner is the Zakia Zafri, who is the actual victim. And the second petition was filed by Ms. Teesta Settleward, who is a human rights activist. So for the application of Zakia, there was no much objection from the state, whereas from the Teesta Settleward's petition, there's several very serious objections were raised by the state. What are those objections? The objection is the first case against this offense. Actually, Zakia has filed a case for murder of his husband, who is a Congress MP, during the communal rights. So this petition was filed first by Zakia in the Metropolitan Magistrate. So she filed a case for killing his husband, Ishan Zafar. So that time it is she alone filed the petition. Teesta has joined only at the level of the High Court. That means when the Metropolitan Magistrate found there is no guilty of the accused, and an appeal was made to the High Court. That is called as a protest proceeding. This protest proceeding was in the High Court by Zakia and also Teesta. So the Teesta has entered into the case only at the High Court. However, she was involved much before because of her role as a human rights activist. But to the court, she came only in the case of High Court. When she also filed the case in the High Court, the Gujarat High Court clearly held that Teesta Setalvad has no locus. That means she has no reason to come to the court. She is not being the victim and she is not the person who is affected by this crime. Therefore, she has no case to come to the court. And the High Court said it will hear only the Zakia's case. And the argument of the state of Gujarat in the Supreme Court is the judgment of the High Court being a final, and in the Supreme when in the Supreme Court, where in the special leave petition in 2008, the Supreme Court did not reverse the High Court judgment. Hence, Teesta has no locus standi and her petition should not be entertained by the Supreme Court. Further, they also severely criticized the role of Teesta, saying that she is using Zakia and exploiting the emotions of Zakia for an ulterior motives to defame the state of Gujarat and also the officials, including the then Chief Minister and the present Prime Minister. So this is the preliminary objection raised in the case. The response of the Supreme Court is that they said, we look at this case, there was a delay. Though there was a delay in filing the case, but previously the Supreme Court has played a very active role in the whole investigation of this, the riots in the Gujarat. They use the phrase called parents patry, that is, the Supreme Court acted as a legal protector of the rights of the citizens because they are not in a position to protect themselves. Therefore, they issued directions to establish special investigation team to investigate the matter. Because the Supreme Court has made a proactive role, they are admitting this case, the special leave petition, even though there is a delay. Second, the court says, I just read what the court says. We do not wish to dilate on the issue of locus standi of Ms. Teesta Setalvad and kept that preliminary objection open to be decided in appropriate case. That means the Supreme Court is very clear, it is going to deal with Zakia's petition only. They are not taking Teesta Setalvad's petition at all in this SL. So they said, in the light, we have granted leave to appeal and decide to examine the matters on merits at the instance of the applicant Zakia Ashan Zafri. So it's very clear that the court is dealing with only the application of Zakia, not Teesta. So I just give you a factual matrix how this case happened. This whole thing started with a Godhra incident where in Sabarmati Express several bogies were tortured and there were about 59 Karsevaks were killed in the fire. Then later, a violent mob was attacked the inhabitants of Gulbarg society, and there were about 69 people belonging to the Muslim community were killed. One of them was the husband of the Zakia. So they filed a case in the court, and also the National Human Rights Commission intervened in this matter, filed a petition before the Supreme Court in 2003, and the Supreme Court appointed Mr. Harish Salve as an amicus curiae. And then when the case was pending, the Zakia wrote a letter to the Director General of Police in 2006, accusing a high-level conspiracy at the behest of the Chief Minister of the Gujarat, and many high-profile officers were involved in the conspiracy. They did not do their duty while the killings are taking place. Uh, then she also filed a petition before the High Court, and the High Court asked them to file a private complaint and dismiss the petition. And then an appeal was made to the Supreme Court. Mr. Prashant Bhushan was appointed as an amicus curiae. Finally, in 2008, the Supreme Court appointed a special investigation team to investigate these cases. The special investigation team was asked to submit its report in 3 months, but it took almost 3 years and filed its report in 2012. And when Zakia asked for the report, the magistrate refused to give the full report of the sit. Finally, she approached the Supreme Court, and the Supreme Court allowed her to have the report. And in 2013, finally, she filed the petition before the magistrate. The magistrate found not guilty of all the accused and given a clean sheet to everybody, because the special investigating team report does not provide any conclusive evidence to show the involvement of the higher officials. Then the case moved to the High Court, and the High Court also dismissed. And finally, the special leave petition was filed in the Supreme Court. That is what this judgment is all about. So when this case was filed, what are the objections raised by the state? One of the objections they raised by the state is that the Zakia was called to examine as a witness in one of the case, that is in Gulberg Society's case, in a trial court. So when she was examined as a witness, she never raised about the conspiracy between the chief minister and the higher officials to keep quiet and allow the killing continue in state of Gujarat. Therefore, their contention is that in 2006, when she complained that there is a larger conspiracy to kill the minority people, it was actually the Teesta Setalwad who instigated her, and at behest of her, Zakia has made this complaint. So then the other objection raised by the city is the statements of Mr. R.B. Shri Kumar, Rahul Sharma, and Sanjeev Bhatt, who are also officials of the government, who testified that there was a conspiracy. The SIT says that these are the only 3 members who said that, but the entire other administration denied the allegations made by these 3 members. So therefore, the state says that there are 3 officials versus the entire establishment. So which one should be accepted? And they also contended that there is evidence to suggest that Teesta Setalwad has fabricated the evidence and forged the documents. So these were some of the objections raised by the state. So what the court observed in the special leave petition? It says, we find that the submissions as not only far-fetched, the submissions of the appellant is not only far-fetched, it is an attempt to undo and undermine the work done by the special investigative team. And the court feels that the special investigative team has thoroughly investigated all the cases assigned by the Supreme Court to the special investigative. And if you are questioning this, it's very strange, but the court says if you are questioning the integrity of the SIT, that is the special investigating team, it is also you are questioning this court, and also the nature of questioning the wisdom of this court. This is the exact words they have used. That means if you are questioning the SIT's investigation, you are questioning the wisdom. And the court says, hence, we assign that the applicant needs to be stated to be rejected. So the court says, we reject it. And then it says, we say no more. There is no problem with this judgment up till now, because the court found or feels that the SIT is conducted unbiasedly an investigation and there is no material evidence to show that the chief minister and high profile officers were involved. However, only the issue till now is whether when the court says SIT report is unbiased, can we question it? If you question that, are you questioning the wisdom of the court? This is the only blemish till now. But then in para 88, what just now I discussed is para 85 of the judgment. Now, para 88, it says, while parting, means while concluding this judgment, we express our appreciation for the work done by the special investigative team officials in a challenging circumstances. We find that they have come out with the flying colors unscathed. It's a very strong statement giving a clean sheet to the SIT. Still, there is no objection for this. If the Supreme Court feels that the investigative team has done a fabulous work, there is nothing wrong in congratulating them. But it says further, at the end of the day, it appears to us that a colossal effort of the disgruntled officials of the state of Gujarat, along with others, was to create sensation by making revelations which were false to their own knowledge. So the court is saying that some of the officials of the state of Gujarat, along with somebody, falsely making these statements in the court to create a sensation. What is the basis for this observation? We have no idea. Then the Supreme Court says the falsity of their claims has been fully exposed by the SIT after a thorough investigation. And it says this case has continued for 16 long years with the audacity to question the integrity of every functionary involved in the process of exposing the devious. So what does it say? It says, the court says it is unnecessarily dragged for 16 years. And you are having an audacity of questioning the integrity of every functionary involved. And further, this is the most objectionable part, at least for me, is it says to borrow the submission of learned counsel for the special investigative team to keep the pot boiling, obviously for ulterior design. As a matter of fact, all those involved in such abuse of process need to be in the dock and proceeded with the accordance of the law. This is an unwarranted statement. So they borrow this statement from the lawyer of the respondent and says that these people, that means the court is inferring that the Teesta Settleward and the other three officials and Zaika kept the case continuously there for 16 years for no reason. And it says all those involved in such abuse of process need to be in the dock and must proceed in accordance with it. What does it mean? Is the Supreme Court hinting that an action to be taken against these matters? So this creates a big issue. So what is the fallout of this judgment? Immediately, the Teesta Settleward was arrested based on the observations made by the Supreme Court. In the FIR, they have heavily relied upon the judgment of the Supreme Court, saying that the Teesta Settleward has conspired and falsely implicated innocent persons. And the FIR shows that she was involved in the forgery using forged documents, forged electronic records, giving fabricated false evidence with an intent to procure conviction of a capital offense, etc. Now, again, the arrest of Teesta Settlement based on the Supreme Court judgment uh, creates several legal issues. The first thing is when the Supreme Court did not consider her application at all in the special leave petition, the Supreme Court justified making such remarks against her. Second thing, if the Supreme Court really felt that she in fact abused the process of administration of justice, is it not the duty of the Supreme Court to give an opportunity for her before making such observation? Remember the beginning what we discussed. The court shows it uh, commitment by giving a reasoned decision. Right? So if the court is not giving any reasons and court is not allowing the other person to present their own case, can the Supreme Court make such observations? Then, if you are all interested, of course, this is a very lengthy judgment, but if you scroll down to the judgment and go to the last part, there is an annexure attached to the judgment. In the annexure, it contains the amicus curiae's response to the special investigative team report. It was given in a tabular form. It's very clear that amicus curiae has identified several places and made observations that the report of this special investigative team does raise some questionable behavior of the state. So though it may not give you, or it did not actually blame them, but there are several places where the behavior of the state is questioned. So therefore, there is no clean sheet. So raising objections about the report in the court, can the court make such kind of observation? The another observation made by the court that 16 years this case was kept alive in the court is an abuse of the process. If you look at the whole case, it's not the behavior of the petitioner that kept this 16 years this case alive. For example, when the Supreme Court gave a 3 months period to the special investigative team, they took almost 2 years to submit the report. Sorry, 3 years to submit. So from 3 months to 3 years. Then after the report, the case was filed in the magistrate. The magistrate took almost 2 years to decide the case. A revision petition in the Gujarat High Court took 3 years. And the special leave petition that was filed in the Supreme Court, which the court decides that there is a delay, it was filed in 2018. The only delay there is 216 days delay by the applicant. That's the only delay caused by the applicant. Out of 16 years, not even 1 year by the applicant. The Supreme Court delivered the judgment in June 2022, almost 4 years. So the blaming the applicants for the delay is not justified. And Justice Madan Lokur, in his write-up, he clearly observed, if the Supreme Court is concerned with the pot being kept boiling with the boiling by the applicants, the arrest of Teesta made this issue still boiling. The Supreme Court has closed the matter, but not the state of Gujarat. These are the words of Madan Lokur. So therefore, the whole case raises few uncomfortable questions. The first uncomfortable question is that in case if a victim of a crime not satisfied with the judgment of the court and the investigative methods of the investigating officer, persisting this case before different courts, would that constitute guilty for the victim? So that means if I am a victim of a crime, and I'm not happy with the judgment of the court, and I keep persisting my case, am I guilty? Second one is, can we question the findings of the investigating agency? If the court believes that the investigative agency has done and findings are correct, can a victim question it? If it questions, would it be questioning the wisdom of the? So the inferences that we are drawing from this is having a far-reaching, what I call implications in future. Then, just to remind you, before this judgment, when the case was reached to the Supreme Court in 2004, Justice Doraiswamy Raju and Arjit Pasayat, while ordering a retrial in the lower court, they said those who are responsible for protecting life and properties, ensuring that investigation fair and proper, seems to have shown real anxiety. That means they say that the investigating officers are not shown any anxiety in investigating the case. The court said the modern day Neros were looking elsewhere when the best bakery and innocent children, helpless women were burned. It's not my words, it is the Supreme Court judge, the observations. Then one gets a feeling that the justice delivery system was being taken for a ride and literally allowed to be abused or misused. The public prosecutors appears to have acted more as a defense counsel. These are some of the observations of the Supreme Court earlier on the same case. So therefore, there were questions. I'm not saying the SIT investigation report is wrong, etc. But there were certain doubts expressed about the way that the investigating officers actually investigated the case. Therefore, persisting such kind of case, I cannot comprehend how that would be an abuse of legal process. How come an observation made by the Supreme Court without listening to the other party could be a ground for arrest? That's an issue. And I also have a few concerns with how the Supreme Court has handled the petition filed on behalf of Nupur Sharma. So you all know that Nupur Sharma has certain comments against Muhammad Prophet, and it created a large-scale violence in the country. So when an application was filed in the Supreme Court asking that there are different FIRs were made against Nupur Sharma in different places that should be clubbed together. So now I'll just, of course, the difference between Zakia's case and Nupur Sharma's case is the observations made by the Supreme Court in Zakia's case is in written. In Nupur Sharma case, I believe it is only a oral observation. I didn't get the order. I couldn't read it. But it was widely reported in the media and the newspapers. My question is, can a court castigate the petitioner? Now, I just read out a few of them. The judge says when the issue was raised before the court about different FIRs, the court says this lady, that is referring to Nupur Sharma, is single-handedly responsible for what is happening in the country. Can we believe this? If somebody made a statement and somebody creates a violence, who is one responsible? Is that the speaker or is the person who is creating that destruction? And the judge says, we saw the debate on how she was incited, but the way she said all this and later she says she was a lawyer is shameful. She should apologize to the whole country. How can a court insist her to apologize? First of all, this case is regarding clubbing of the FIRs. And it says, the court also asks, when an FIR is registered and you have not arrested, What does it mean? Does it mean that the court is saying that once an FIR is registered, we must arrest the person whose name was mentioned in FIR? This goes completely out of the criminal jurisprudence and even the principles of constitution. The late 70s and 80s, when Justice Krishnaiyer was a judge of the Supreme Court, brought completely a new criminal jurisprudence under the Constitution. Bail, not the jail, is the slogan. But today we are saying that once an FIR was made, should be arrested. And the most bizarre thing is that what was the TV debate for? These are the words of the judge. Was it for a fan an agenda, and why did they choose a sub judice topic? What is the business of the TV channel to discuss the matter which is sub judice, except to promote an agenda? So the Supreme Court, is it telling us that if a case is pending before the court, we cannot discuss at all? Now, to the viewers, we have a freedom of speech and expression protected as a fundamental right under 19(1)(a). That is Article 19(1)(a). And this freedom is enjoyed all the citizens, including the press. And constitutionally, this freedom can be restricted only by 8 grounds mentioned under Article 19, Clause 2. Only 8 grounds. And sub judice is not a ground. Does the Supreme Court hint us that the sub judice is going to become a new form of restriction, a 9th ground of restriction? Can the court stop TV reporting, discussing about the case? The case of, then another thing, very baffling statement made by the court is the case of a journalist expressing his right on a particular issue is on a different pedestal from a spokesperson of a political party. What does it mean? Does it mean freedom of speech and expression differs on the basis of the social and other status of the individual? If you are a journalist, you can say something, but if I'm not a journalist, but I am a political party leader, I cannot say the same thing. Then look at the other thing. She has a threat, or she has become a security. That means the court is hinting that a mere criticism on a religion becomes security threat. Then the court says, what has Delhi police done? Don't make us open our mouth. So these are all unwarranted statements. Now, I completely understand that there were criticisms that the state is behaving differently when the accused belonging to a different religions. That is a different issue. But the court cannot make these kind of statements. Now, what is the problem? Now, if we look at over a period of time, I'm not looking at only these two as an isolated cases. As Mr. Veeraya has already identified, the Supreme Court decision on the Maharashtra issue is also an issue. But if you look at over maybe a decade, the court on several persisting important matters kept its silence. I can give you a list. So for example, the hate speech. This hate speech is going more than 10 years, and the court is not clearly telling the state how to act. Now, the question is, when we have a freedom of speech and expression, does it include a criticism against the religion? Is the religion above everything? And unfortunately, it is not so. If you read Article 25, under which freedom of religion is recognized as a fundamental right, clearly says, subjected to public order, morality, and health, and the other provisions of this part. That means your freedom to have a religion or religious freedom is subjected to other fundamental rights. If there is a clash between one fundamental right with religion, it is the other fundamental right that will prevail. So if my speech and your religious belief have any clash, my speech will have a upper hand over your religious freedom. It's very clear. Why can't the court decide once for all and say that this is the stand, this is the law? Remember the demonetization. When the demonetization case was filed before the Supreme Court challenging it, till now the court has not decided. And you all know that the court is not willing to decide because there is no use even if decided to. See, when a case was filed before the Supreme Court, again, I'm not telling demonetization good or bad. I'm saying that we have a right to question the decisions of the government if they violate my principles of fundamental rights. So somebody challenged before the court should have decided whether it is violation or it is not violation. That is what we are all asking from the court. Similarly, Article 370, how many years it is pending, how many years the citizenship issue is pending, and how many years the sedition issue is pending. So therefore, there are several issues on which the court silence also creates this kind of problems. So what I'm trying to tell you is that the Supreme Court judges have a highest constitutional obligation to repose the faith of the people on the Constitution. The Constitution gives them power, but the Constitution also tells them to act within the parameters of the Constitution. They are not answerable to others, but they are answerable to themselves. They are answerable to the Constitution. When I said they are not accountable, doesn't mean that there is no accountability at all. What I'm saying is their accountability is a higher accountability compared to legislature and executive, in a sense that there must be a self-restriction on the judges what to say and what not to say. Because if they don't do, this is the only institution at least command some respect from the public, would lose that trust. Remember during the emergency what happened, the role of the courts were severely criticized. And we don't want to go back to that level that the courts are not in a position to protect the rights of the citizens. If the citizens lose their trust against the court, then there is no other organ that we could turn to it. So therefore, it is the time that the judges should need to self-introspect how they should do observations in judgment, whether these observations, particularly the sweeping statements made by the judges while on the bench, need to be controlled by themselves. So this is where I'm going to stop. Gregor, any questions?
I think one more aspect you should reflect on, sir. Several commentaries, it was identified that this particular judgment has not been authored by any of the judge, and no judge has owned the authorship of the judgment.
Which judge? Which one?
Of the Jacquias judgment.
No, Jacquias judgment, all the three judges were there in the...
They were there, but even Prashant Bhushan, Madan Bilokur and other legal luminaries says it was not owned by any. It was not.
No. See,
what is the procedure involved in that authoring the judgment and kind of the procedural aspect?
Yeah, it doesn't. That's true. I also observed that it doesn't say who has authored this judgment. Only simply down there, the three names of the judges were there. Justice Kanvilkar, Justice Dinesh Maheshwari, and Justice Ravi Kumar. These are the three judges' names were there. I agree what you are saying, that usually when the judgment is written, one judge would say that I am writing this judgment and on behalf of other judges, but that is not there. That's a very critical observation. I agree that. And also there are many judges and bureaucrats wrote to the Supreme Court to give a clarification that they did not intended that the arrest of the Teesta Shettiwad is necessary under the judgment, but the Supreme Court was silent about it.
So you mentioned in the initial comments, Supreme Court of India is considered one of the powerful
Yes.
Supreme Court or judiciary, part of
Yes.
judiciary in the whole world.
Yeah.
And that power, that powerful identification or recognition of that strength is emanated from the slow of public interest litigations that changed the course of judiciary in 1970s and 80s.
Correct.
And it is not to offend anyone, not because of the bulky judgments that runs into thousands of pages.
No,
I'm coming to that core question. The Supreme Court, in this particular judgment, while dismissing the Jagia's petition, commented that civil society activism, they commented on, those who are sitting in the comfortable environment in their air-conditioned offices betrays the brazen attack of understanding of civil society.
Yeah.
So, as you mentioned, there is no need to go into other aspects which is not part of the frames, issues framed by the judiciary.
Exactly.
So this kind of statement is, I see the resemblance of the initial 2014 and 15 when senior most ministers in the cabinet, those who are continuing till now, commented on the public interest litigation, the nature of public interest litigations, and this. So how do we look at this?
Now, one thing is that let me answer why we say that it's a powerful court in the world. It's because the Supreme Court, in number of cases, taken cases on so based on the reports of the newspapers. I'm talking about particularly in the 80s. Of course, one of the observations made by one of the legal luminaries is the Supreme Court invented the fund public interest litigation to gain its trust among the people because they lost during the emergency. But whatever it is, the Supreme Court started accepting letter petitions addressed to judges would be turned as a petition. Even the reports of the newspapers was accepted as a fundamental, as a writ petitions. So therefore, and also, if you look at the number of judgments where the policies were created by the Supreme Court, the whole right to education and education policy, engineering and medical college, their admissions, the Supreme Court even sat in some of the judgments and gave the calendar how to admit the students. To that level, it went. Maybe it is required. I'm not sure. I'm not questioning their wisdom. And it went on to say that sexual harassment at workplace is an offense, created a new law. So therefore, obviously the Supreme Court has, over a period of time, assumed more powers, particularly because of the non-trusting legislature and executive. So therefore, the Supreme Court was given an opportunity to do that. That's what we call judicial activism. Hence, in number of cases, the Supreme Court, under the garb of Article 142, started giving orders, even though they were not asked, for the purpose of doing complete justice. Therefore, the question now today is whether we should allow the courts to see whether should we allow the court to make these kind of observations and comments when they are not the issue at all. So that is what the accountability, that is what I'm talking. The court should restrict their observations to what is necessary based on the petitioner's plea. Number two, if the court thinks that the petitioner did not ask something, but that is necessary for the purpose of protecting the petitioner and his rights, the Supreme Court has an every right to do. But if you are questioning the petitioner's integrity without listening to the petitioner, that is the area of concern.
I think we can.
And I think there is one comment made
Yeah,
by,
I'm coming to that.
yes,
I'm coming to that. Setting motion the criminal law.
yeah,
That became an issue or series phenomena now,
yeah, yeah,
particularly in post 1992.
yes,
Whenever there is a best example when Gujarat MLA made some comment on Twitter, and somebody set the law in motion in Guwahati,
correct,
and Assam police flew down to Gujarat, Ahmedabad, and found him while addressing in a mohalla meeting.
yes,
So likewise, the whole principle has been laid down by in Antule case, the famous Antule case. That
yes.
was the one era of Supreme Court interpretation of setting the motion criminal law,
No,
and
no.
we are looking at a different aspect of the
No, no.
setting.
See, the problem, what happened, the era that we are talking about on Pule's case, where there is no internet explosion, there is no social media. So therefore, if anybody wanted to make any statement, the statement should be either made through a newspaper or a journal or by a radio where there is a screen. But today with the social media, there is nobody to screen, like nobody is an editor for it. If Viraya wanted to write an article in Andhra Jyoti, then the Andhra Jyoti editor would read and edit it. But if you are posting in your Facebook or Twitter, nobody is there to edit. Plus, this is reachable within a minute to the entire country or in the entire world. Therefore, there is a chance of multiple FIRs are filed against the same offense. This is kind of a slap suit, means to reduce the people's freedom of expression. They file these cases purposefully in different ways. So that's why the Supreme Court very clearly said, in case of multiple FIRs, all the FIRs should be clubbed. So that is precisely the Nupur's application to the Supreme Court. Supreme Court could have simply said, go to High Court and make this plea, and the High Court will club them. Instead of doing this, the unnecessary comments were made. That's the problem. Okay. So therefore, now you had, because of the technology, now you have multiple cases. That multiple cases can be transferred. There is a law already set. Coming back to that criminal law, who anybody can set motion, yes. But this case says, if I am over enthusiastic and continuing and persisting the case, there is every possibility that later, if the judgment is going against me, the police can arrest me. That's kind of narration that we are getting.
So the last observation from the judgment,
Yeah.
Because that portion has been now become part of the final judgment on Jakia Jaffrey case.
Yeah.
When the petition alleging the role of 63 individuals has been filed, the Supreme Court directed the petitioner to follow the procedures under CRPC.
Yes.
Under section 200, you have to file the petition. The petition has not been in the proper format as prescribed by law.
Yeah.
And now it became final part of the final judgment. So do you think that this kind of acceptance will be there will be a doom for era of public interest litigation? Because as you mentioned, even newspaper became a cause of action, the postcard became a cause of action, setting the law in motion. Now, instead of that, if you are directing the petitioner to follow particular path, instead of invoking the constitutional remedies.
See, there is one of the observation that was made in a research on the Supreme Court. It shows that 85% of the petitions accepted by the Supreme Court is through SLP, special petitions. And there is a severe criticism against the Supreme Court that it is failed to discharge its duties as a constitutional law. Instead of becoming a constitutional court, more constitutional court, it is becoming an appellate court. Okay, so let me give you an example. In America, there are 9 judges, and all the cases are decided by the 9 judges. So very few cases will go to the American Supreme Court, that too relating to the Constitution of the United States of America. Whereas in India, practically every judgment or every order given by any court, from the lowest to the high court, you can make an SLP to the Supreme Court. That is what Article 136 gives. So by invoking this and an encouragement by the Supreme Court, you could see that there are more than 70 to 80,000 cases are filed every year, which is a large number of cases that the Supreme Court not in a position to handle. And then we have this system of division bench, most of by the division bench. Now, say for example, division bench A decides a case on environmental law issue. A similar issue goes to another bench later. They may not be in a position to know what this bench has said. So there are chances of quite contradictory judgments are coming. As per the rule, you cannot override the judgment of the higher number of judges. Even if the equal number, suppose this is a 3-judge bench, ours is also 3-judge bench, we cannot go against them. If we want to go against them, we have to refer to the Chief Justice to refer to a larger bench. So because of these these kind of problems, it's very difficult to track the judgements of the courts. So that's one of the problem. And in this scenario, I don't see that the Supreme Court is going to accept more and more public interest litigations, even though they are important to decide.
So the basic objection to this whole appreciation of the facts.
Yes.
That Jagia's issue goes back to the appreciation of the facts, because Gujarat former Home Minister himself deposed before the concerned citizens tribunal, and that was manned by eminent jurists who served the highest
Yes.
judicature of the country. Along with that, the serving officials like Rahul Sharma, who collected, he is in a position to depose before the Nanavati Commission and provide all the factual information before the Nanavati Commission. He provided bulk of the telephone calls secured from the various telephone service providers, and to map the actual scene of offense or construction of the crime. So the basic allegation of Teesta Setalvad and in that particular protest petition and also Jakia Jaffrey's is that this vital information, factual information, has not been considered by the special investigation team. Correct. So that's why we are coming before the Supreme Court.
But the Supreme Court doesn't believe in that, because the Supreme Court says the SIT has clearly established that these call records and the call data cannot be clearly established the position. And also, I think some of the documents are not available. And the statement of those three, whether they were there at the time of the meeting, etc., they cannot vouch for it. And particularly after that Sabarmati train incident, one of the allegations were that the charred bodies were taken on a parade. But however, the SIT says that there is no such parade. And but the bodies were handed over to a person who is not a relative of them. Therefore, the amicus curiae in his observations mentioned, unless somebody, a higher official, has instructed, usually the dead bodies are not given to non-relatives. Non-relatives. That's why if I request all the viewers to read this judgment, not the whole judgment, it's a lot of difficult to read the whole judgment, but the last annexure, where they had given in a tabular form what are the objections raised by amicus curiae. Amicus curiae did not give a clean sheet.
So in the same judgment, I think at one place, I could not refer the page number now. It says is the admission submission from the council of the SIT on behalf of the SIT. The SIT filed in its submission that due to technical reasons, we could not interrogate or inquire with the Chief Minister of the state. Yeah. So here my question is, when the Chief Minister is alleged or convicted or becomes party to the an FIR or whatever the crime in financial issues like corruption, misappropriation, he will be, there is no technicalities coming in the way in inquiring the chief minister.
Yeah, but we don't know what are the technicalities they are speaking about. Whether it is non-availability of the chief minister, whether there is a permission that is not given, we don't know.
So non-availability of the chief minister for 3 months, 3 years to the same.
But of course, anyway, this
Yeah.
discussion is not about whether the sit has
The sit,
conducted
yes.
properly or not. That's not the purview of this argument.
Right.
But our issue is only what extent the Supreme Court could make such kind of observations. Whether it is better to avoid, I feel yes, it should have been avoided those kind of comments.
The whole presentation comes down to the accountability.
Exactly.
Accountability of the judiciary.
Judiciary.
So do you think that is there any means or ways that can be
see one
arrived at,
yeah
like
one
a
problem.
judicial commission, national judicial
Yes.
commission?
That is what one I'm coming to. We heard that power corrupts man. Absolute power corrupts absolute. Now, nowhere in the world judiciary appoints themselves except in India. That's why I said Supreme Court is the most powerful power. In even the best democratic countries, the appointments are done by the Judicial Commission. The best example is in England. So therefore, when the National Judicial Council or committee is appointed, unfortunately, it was struck down by the Supreme Court as unconstitutional. Except Justice Chalameshwar, all the judges were against that amendment. So one of the observation made is, say for example, before 1993, that is before the Supreme Court Advocates Association case where the Supreme Court said collegium system was introduced. Before that also the judges are appointed by the executive. And whether taking that appointment into the hands of the Supreme Court, did the Supreme Court improve the quality of the judges? That means the judges who are appointed before 90 and the judges who are appointed after 90, is there any visible difference in the quality? Because if the Supreme Court thinks that it has become independent, then the quality of the judges should have been improved. Somebody has observed that a lot of hierarchical things are happening in the judiciary. After army and defense, I think the most hierarchical is the judiciary. Looks like, of course, I'm not sure. I don't know. That was one of the observations made by somebody. I have no in-depth knowledge in that. But I think the National Judicial Commission would be a better way of appointing new judges.
Thank you, sir.
Thank you.
You really made up to the absence of Justice Nagmohan Das Garu. And we do hope the people will realize, those who are watching and those who will be watching in times to come, they will realize the need for accountable judiciary, which will be, as you mentioned, as the last sentence of your presentation, that will impact the quality of the judiciary as well as quality of the judgments. With these closing remarks, I thank you once again, and we do hope we will call you once again for the appropriate time and an appropriate topic.
Thank you.
Thank you.